In March of last year, the Washington legislature passed a law banning the sale of ammo magazines that hold more than 10 rounds.
The state's law in limiting ammunition magazines to 10 rounds as unconstitutional.
Across Washington state, so that includes new gun safety laws, which not only impact gun owners, but gun shops as well.
These laws come into effect in the aftermath of mass shootings that have rocked the state and nation.
So those that carry over 10 rounds are now illegal to make, buy, sell, and import as of today.
15 rounds is probably your most common carry capacity in most modern day handgun.
Mag capacity restriction. The United States Supreme Court invalidated the state's ban on open carry of hand arms for self-defense in last year's case of New York State Rifle and Pistol Association versus Bruin. A week after Bruin, the Supreme Court rejected 4 decisions from appellate courts that had supported state arm control laws and returned the cases for further review. Duncan and Bonta is one such case where a federal court found that the California legislation prohibiting mags with more than 10 rounds was unconstitutional.
In March of last year, the Washington legislature passed a law banning the sale of ammo magazines that hold more than 10 rounds.
He believes limiting the number of rounds you can carry only hurts lawful gun owners and their ability to protect themselves.
Some gun owners also told us that they believe it's the people, not the guns, that are the problem. And this is how some reacted just before the law went into effect.
15 rounds is probably your most common carry capacity in most modern day handgun.
The court's decision was announced on Friday. U.S. District Court for the Southern District of California Judge Roger Benitez says there is no American history or tradition of regulating arms based on the number of rounds they can shoot, or of regulating the amount of ammunition that can be kept and carried. Because the state did not succeed in justifying its sweeping ban and dispossession mandate with a relevantly similar historical analog, is hereby declared to be unconstitutional in its entirety and shall be enjoined. To provide California time to appeal his decision, Benitez delayed his injunction for 10 days. It was already Benitez's opinion that the mag capacity restriction in California was unconstitutional because it infringed the Second Amendment. While the case was still in its early stages, Benitez issued a preliminary injunction against Proposition 63, a 2016 ballot initiative that would have outlawed the possession of what California calls large capacity mags, or LCMs, in 2017. While prior laws had allowed for the continued possession of mags bought before the ban, this plan would have tightened a 2000 law that banned the manufacturing, importing, and selling of LCMs. After a 2-year extension of the previous limitations on LCMs, Benitez made the decree permanent. California's law prohibiting acquisition and possession of mags able to hold any more than 10 rounds places a severe restriction on the core right of self-defense of the home, such that it amounts to a destruction of the right and is unconstitutional under any level of scrutiny, said he.
The state's law in limiting ammunition magazines to 10 rounds as unconstitutional.
It is the bill Ferguson has been trying to get passed since 2016. That year, a 19-year-old used a high-capacity rifle.
California cannot ban gun owners from having high-capacity gun magazines.
Is it the most robust, far-reaching gun law in the history of the world? It is not.
Prior to the year's Supreme Court invalidation, a 3-judge panel of the 9th Circuit upheld the verdict. However, in a 2021 en banc opinion, the circuit reversed the decision. The case was then sent back to Benitez by the 9th Circuit. This time, the plaintiff's case had more weight. The plain text of the Second Amendment allows for laws to regulate certain actions, and Bruin argues that these laws must be consistent with this nation's historical tradition of arm regulation. California struggled to pass the test. In response to a request for more time to review the archival materials, the state produced a list of 316 laws covering 550 years from 1383 to 1933. Since many of these statutes were written either before or after the ratification of the Second Amendment in 1791 or after the 14th Amendment mandated that states maintain the right in 1868, Benitez claimed that they are not relevant when considering the original public view of the right to bear arms. Almost all of the other discussions center on issues unrelated to mag capacity limitations, such as transportation and handling regulations. Legal analysis. In recent years, debates surrounding arm control laws in the United States have intensified, leading to significant legal battles over the interpretation of the Second Amendment. One such battleground is California, where restrictions on mag capacity have been at the forefront of legal challenges. The recent decision by U.S. District Court Judge Roger Benitez to invalidate California's ban on large-capacity mags or LCMs in the case of Duncan versus Bonta has reignited discussions about the scope of Second Amendment protections and the role of historical precedent in shaping arm regulations. The crux of Judge Benitez's decision rests on a meticulous examination of historical analogs to California's mag capacity restrictions. In evaluating California's argument, Benitez scrutinizes the state's attempts to draw parallels between modern arm regulations and historical laws regulating arm powder storage or concealed carry of arms. He dismisses these comparisons as tangential, emphasizing that historical regulations primarily focus on public safety concerns rather than the specific issue of mag capacity for arms. Benitez highlights the absence of any long-standing tradition of limiting ammunition capacity in American history. While acknowledging the evolution of arm technology, including the invention of detachable mags in the late 19th century, he argues that historical precedent fails to support California's imposition of a 10-round limit on mag capacity. Moreover, he points out that laws regulating arm possession and use have historically allowed for a wide range of arms, including those with high-capacity mags. The decision underscores the arbitrary nature of California's mag capacity restrictions, labeling them as capricious and extreme. By scrutinizing the historical context and intent behind arm regulations, Benitez challenges the rationale behind California's ban on LCMs. He argues that such restrictions undermine the core principle of self-defense enshrined in the Second Amendment by depriving individuals of effective means to protect themselves and their families. California's policy argument, which emphasizes the potential risk posed by LCMs in mass-slaying scenarios, fails to sway Benitez.
These laws come into effect in the aftermath of mass shootings that have rocked the state and nation.
They are still legal to use and carry, but you had to pick them up before today.
But California Attorney General Rob Bonta argues they aren't necessary for private self-defense.
Limiting magazine capacity forces shooters to pause to reload.
He questions the validity of these statistics, suggesting that they may underestimate the frequency of situations requiring higher mag capacities. By scrutinizing the methodology and assumptions underlying California's arguments, Benitez underscores the need for rigorous empirical evidence to justify infringement on Second Amendment rights. Moreover, Benitez highlights the widespread ownership of mags exceeding California's capacity limit, emphasizing their common use among law-abiding citizens for lawful purposes. He notes that such mags are integral to the exercise of self-defense rights, particularly in scenarios where individuals may face multiple assailants or extended threats. By acknowledging the prevalence of high-capacity mags and their importance in self-defense, Benitez reinforces the constitutional significance of protecting access to arms and ammunition suitable for lawful purposes. Judge Benitez's decision in Duncan versus Bonta offers a comprehensive critique of California's mag capacity restrictions, grounded in historical analysis, constitutional principles, and empirical evidence. By challenging the rationale behind such restrictions and emphasizing the primacy of self-defense rights, Benitez reaffirms the fundamental protections afforded by the Second Amendment. The decision underscores the importance of judicial scrutiny in evaluating the constitutionality of armed regulations and ensuring that laws respect individual rights while addressing legitimate public safety concerns. Washington defends arm laws. The Attorney General's office in Washington has successfully defended multiple state laws against legal challenges brought by pro-arm advocacy groups. These victories highlight the state's commitment to enacting and upholding arm regulations aimed at promoting public safety and reducing armed violence. One significant case, Brumback versus Ferguson, involved a challenge to Washington's ban on the sale of high-capacity mags.
So those that carry over 10 rounds are now illegal to make, buy, sell, and import as of today.
Across Washington state, so that includes new gun safety laws, which not only impact gun owners, but gun shops as well.
Members of Congress are also trying to answer what the Attorney General just called the most difficult question in a democracy.
Having high-capacity magazines, the judge says there's no American tradition of limiting ammunition capacity.
Another notable legal battle involved Guardian Arms versus Inslee, where plaintiffs challenge House Bill 1240, which bans the sale of attack weapons in Washington. Despite efforts to obtain a temporary restraining order and a preliminary injunction, the state successfully defended the law, allowing it to remain in effect. Although the plaintiffs appealed the decision, the state Supreme Court denied their request for discretionary review, further cementing the law's validity. Similarly, in Hartford versus Ferguson, plaintiffs challenged the same attack weapons ban under House Bill 1240. Again, the court denied the plaintiffs' motion for a preliminary injunction, indicating the state's success in defending its arm regulations. Like other cases, this one is also stayed pending the outcome of Duncan versus Bonta, underscoring the interconnected legal landscape surrounding arm control. Finally, Silent Majority Foundation versus Inslee involved a challenge to House Bill 1705, which bans ghost arms in Washington. Despite initial attempts to obtain a preliminary injunction, the court denied the plaintiffs' motion, allowing the law to stand. Although the plaintiffs appealed the decision, the Court of Appeals declined to review it, further solidifying the state's position on arm regulations. Overall, the Attorney General's office in Washington has demonstrated a strong track record in defending state laws against challenges from pro-arm advocacy groups. These victories underscore the state's commitment to promoting public safety through sensible arm regulations despite ongoing legal battles and opposition from the arm lobby. As the legal landscape continues to evolve, Washington remains steadfast in its efforts to prioritize public safety and reduce armed violence through effective arm legislation. That's all for this video, folks. See you next time.